Welcome to the Sui Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. This is going to be Erica's last show with the Sui Generis Show as we transition to a new format and introduce co-host and show writer Elizabeth Emilia Osorio Esquire. Today in segment 1, we'll be discussing the investigation of Brian Laundrie for the murder of Gabby Petito, the recantation of an eyewitness's testimony 60 years after her testimony convicted an innocent man, and the civil rights lawsuit filed in Colorado by a deaf man who was abused and incarcerated by police for over 4 months. In segment 2, as promised, we'll be talking about driving privileges and when a driver's license has been suspended in the state of Ohio. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube, and follow us on all of our social media channels. Look to the law office of brianjones.com for everything you need to know about your civil rights and the criminal injustice system. So, Erica, did you see in the news this week, national security experts expect Brian Laundrie's parents to be called into the grand jury to provide testimony in the investigation of the alleged murder of Gabby Petito?
I did, and it is such an interesting case. The story of Gabby Petito's disappearance and murder has been in the headlines. Can you bring us up to speed on law enforcement's response to this situation?
After Gabby was reported missing, her fiance, Brian Laundrie, has been investigated and accused of improperly using her debit card for more than $1,000 in purchases. But he's not been charged with her murder, though he remains a suspect and a homicide investigation is ongoing. Laundrie was found to have returned to his family home in Florida without Gabby and with her car and things. Now, his parents were identified as potential witnesses by the FBI. They were interviewed, but they've retained counsel, and their counsel is saying that the allegations of lack of cooperation with the investigation is untrue and that they are participating in the investigation to the extent that it is appropriate.
Wow. So why would a family of the accused be called to testify at the grand jury?
Being an accessory to a crime after the crime has been committed can occur in a variety of ways, Erica. Intentionally impeding or interfering with a government investigation is called obstruction of justice, and it can be anything from a misdemeanor to a felony with penalties in the range of days in jail up to decades in prison. Now, tampering with evidence is the destruction of things like documents, clothing, digital records, anything that creates some sort of connection or provides some evidence to continue the investigation. Its destruction can be a crime in and of itself. And any action that creates a risk of harm to a person can increase the severity of these charges. Now, helping somebody evade law enforcement capture, helping somebody hide evidence of a crime can also be either obstruction of justice or tampering with evidence. And when these things involve wire transfers, falsifying documents, and lying to FBI agents, they now become federal offenses. Now, this family has retained defense counsel that's going to help them navigate their response to both being witnesses against their son and simultaneously investigated for assisting him in the cover-up of the alleged murder.
Wow, that is so interesting. I mean, typically you'd want to, when you see something, say something, but I guess when it's a family member, it's a little tougher for some people to do that. Now, is it possible for them to plead the Fifth and not say anything about what they know?
The Fifth Amendment protection guarantees the right to be free from self-incrimination. So the government can't force you to give evidence, oral evidence against yourself, but it provides no protection for knowledge that you have about other people's crimes. Now, a refusal to testify in court can be seen as contempt of court. All we have to do is look to the famous case of Josh Wolf, who was a journalist and jailed for over 200 days in 2006 for refusing to turn over evidence that he collected during his work as a journalist. Now, here's the catch to all of this, Erica. Nobody has to speak to the police under any circumstances. So just telling the police, I'm not talking to you, I don't want to participate in this, is not a crime. That's not obstruction. That's not tampering. That's not any sort of illegal conduct. Lying to the police is, and then if they are subpoenaed into court, refusing to comply with the terms of that subpoena is also, it's contempt. So it's not exactly a crime. Contempt kind of sits in a gray area between a civil consequence and a criminal consequence. But to answer your question directly, you cannot raise the Fifth Amendment as a defense to testifying against your loved one, but you can also choose to not say anything to the police. So there are options available. And as you can see, Erica, it gets very nuanced when we're talking about these sorts of situations.
Yeah, I mean, it is incredibly interesting. I can't wait to hear about what happens when they bring the family in to testify.
Absolutely, Erica. And I think one of the reasons the prosecutors are going to subpoena them into the grand jury is because it gives them the opportunity, the prosecutors, the opportunity to question these family members, without them being able to refuse to answer the questions. So in this case, Brian Laundrie's parents are going to provide some sort of information, although it's going to happen at the grand jury. Now, another person that provided information, Erica, was a woman who falsely accused a man of raping her 50 years ago in Boston. Did you see this news this week where she's come forward and admitted she identified the wrong person?
God. So I know we've talked about this possibility, but I can't believe that this happens so often.
Tyrone Clark has been in prison since 1973.
Well, bring us up to date then on the circumstances of the alleged crime that happened 50 years ago.
So 1973 in Boston was a racially charged time, and social tension between the police and the public, and in particular the police and the Black community, was at a critical level. Police officers responded to an allegation of rape, but they failed to collect evidence that was available at the scene, including the clothing that was worn by the accuser and alleged semen that was present at the scene. Now, the accuser ultimately secured the conviction of Tyrone Clark, who was at that time 18 years old, based almost entirely on her eyewitness identification testimony. He was convicted, and he has to this day maintained that he did not commit this crime.
Thank God for technology that has come up throughout the years, but for the people back then, you just want to cry for them. It's horrible to waste your life that way. That's something that you can never replace. So, is mistaken identity a common problem in the prosecution of an alleged crime?
It is a huge problem in the field of wrongful convictions, Erica. Eyewitness identification is one of the least reliable types of evidence out there. More than 2,850 people across the United States have been exonerated since 1989. 1 in 4 of those wrongful convictions included an eyewitness misidentification. Research has shown for decades that although witnesses portray themselves as confident that their memory is accurate when they identify a suspect, the reality is that memory is malleable, and visual perception makes eyewitness identification testimony one of the least reliable forms of evidence that can be submitted in court. Any criminal case that involves an eyewitness, whether it's offered at trial or not, must be closely scrutinized. and may require the assistance of an expert witness. Because the reality is, Erica, people think their memories are like a video recording. And when witnesses get up on the stand, they're just playing that tape back and orally narrating what they're seeing in their heads. The reality is much different. I don't know if you remember Silly Putty, but you can take Silly Putty and you put it on a newspaper. Do we even remember newspapers? And when you peel that Silly Putty off of the newspaper, the print would stick to the Silly Putty, and then you can stretch it and twist it and make it look almost nothing like what the print on the paper was that it pulls it off of. Memory isn't even that accurate, Erica. Our experiences, our traumas, our perceptions, misperceptions, and paradigms all factor into what that end result looks like 1,000 random clicks in a video photoshopped into our brains.
Wow, that is such a great example of what happens. So, heck, we've talked about in the past what happens to somebody's reputation when they are just falsely accused and they get off and they try to go on with their life. What does this mean for the accused and the accuser that this crime has been recanted? This accusation has been recanted.
Tyrone Clark, through his attorneys, has filed a motion for a new trial. And upon review of the evidence in support of that motion, the recantation of his accuser, and on the basis of a full case review by the Conviction Integrity Unit of Suffolk County, the district attorney's office has decided there will be no further prosecution of Mr. Clark, and he will likely be released. His sentence will be terminated for this rape conviction.
Now, do they give him any kind of compensation for being wrongly accused and wasting 2/3 of his life? I mean, who knows how long he's going to live, but I mean, that's 50 years is a long time.
50 years is a long time. And it seems like Mr. Clark may have had other reasons to be incarcerated, other convictions that he was serving time on. So he may or may not be entitled to compensation, depending on how those sentences played out.
Okay. Thanks for clearing that up.
Absolutely, Erica. And speaking of things that didn't play out quite as expected, Erica, did you see the story of Brady Mystic, a deaf man who was tased and locked up in Colorado for 4 months with absolutely no help because nobody bothered to get a sign language interpreter to understand what he was saying?
Wow. I mean, that seems like a crime in itself. How did Brady Mystic, a deaf person, come to the attention of law enforcement to begin with?
Well, he allegedly ran a stop sign, Erica. He was pulled over for a traffic violation. And because he can't read lips and he only communicates through sign language, he was unable to understand the commands of the officers that pulled him over. So they said that he was non-compliant with their orders, tased him, slammed him into the ground, handcuffed him, and ignored his pleas of no ears in an attempt to inform them that he didn't understand them. And then they locked him in jail for 4 months, where nobody ever came to talk to him who was certified in American Sign Language. For 4 months, Erica, he sat in a jail cell, unable to communicate with anybody. And that's why he has now filed a civil rights lawsuit in response to this violent arrest and 4 months in jail.
I mean, that is horrible. Is it a violation of your civil rights to deny you an interpreter if you need one? Because I know there's lots of situations where a police officer may not know whoever they're arresting's language. So what happens in this case?
Under the Americans with Disabilities Act and its enacting regulations, both state, federal, and local police officers are required to provide reasonable accommodations, such as qualified interpreters, real-time captioning, assistive listening devices, or other services to make sure that they can communicate with people that are legitimately part of the community that they are supposed to be serving and protecting, particularly in this case, the deaf and the hard of hearing. Now, knowing a person needs an accommodation and ignoring that fact is an absolute violation of the Americans with Disabilities Act and will form the foundation of his lawsuit.
I mean, I'm glad that he's got help now because it's a terrible injustice. So is diversion a fair outcome for Mr. Mystic's criminal case?
So he faced a variety of charges, not just the accusation of resisting arrest. It's hard to say whether this is a good outcome for him without knowing the specific facts of his particular case. Participation in diversion is typically both a short and long-term positive. In the short term, it gets your case done really quick. In the long term, the conviction is supposed to be off of your record for the rest of your life. The other thing is, Erica, is that sometimes an accused person has to make a practical decision rather than an idealistic one. And that's their right. It's his life, and he's got to live with the outcome of his choice. Certainly some convictions could result in eligibility issues for programming and support that he would otherwise qualify for as an American with a disability. So, is it the right outcome? Is it a fair outcome? It's hard to say, but it's the outcome that Mr. Mystic chose.
Well, I'm glad that you're bringing us up to date on this because I'm sure we could do an entire show on this particular topic.
Oh, absolutely, Erica. And, it may seem like this is something that's few and far between, but I've handled a case almost identical to this. We had a young lady that was accused of a crime. An officer came out and interviewed her. She explained to the officer that she was deaf. She didn't, she didn't speak the same way as hearing people do, as deaf people often do. And so there was confusion going both ways. He didn't understand what she was saying. She didn't understand what he was saying. And the worst part about our case, Erica, was that she had a dry erase board. And she tried to write down and show the officer, look, this is how we need to communicate. And he refused to accommodate her in that simple manner. So that case got dismissed real fast.
Yeah, well, that sounds terrible too. It's a horrible thing to have to worry about that. We talk about just being the wrong color, but like not even being able to communicate as well. I mean, it's scary. It's a scary world out there.
Scary world anytime there's a police officer around. That's absolutely right, Erica. Speaking of situations that police officers may be around, on the road, driving is a privilege and not a right. Most people don't understand that. Most people think that you have a right to drive your car. But the reality is that it is a privilege. And in order to exercise that privilege, you must have a valid license to operate that car. 1 in 20 licensed drivers are suspended at any given time in the state of Ohio. And that number doesn't even account for those that have never been licensed or have had their license canceled. Now, there's a key distinction between having an active license and a valid license. An active license means that your license hasn't expired and it's within the time frame that's printed on its face. A valid license means that you've also met all the legal requirements to be on the road and operating a motor vehicle. Today, Erica, let's talk about why licenses get suspended and what an attorney can do for you to help get back on the road legally.
Yeah, I mean, that is interesting because obviously the first thing you think of when you think of somebody losing their license or their right to drive is a DUI or maybe a crime being committed or something like that. Are there other reasons that someone may have their license suspended?
Oh, absolutely. So in addition to getting an OVI, a person's license can be suspended because they've had multiple traffic violations in a 12-month period, or over a period of 2 years if you accumulate enough points over that time frame as well. It can be suspended for failing to pay child support. It can be suspended for paying failure to pay court costs. And there are a variety of other convictions in the criminal code that can result in a license suspension. But you don't have to commit a crime to have your license suspended. If you get in a traffic accident, completely innocent traffic accident, and let's say your insurance doesn't have enough coverage or refuses to pay the other driver, and the other driver's insurance covers all their costs, and they sue you, that insurance company can have your license suspended for not paying that civil judgment. Licenses can also be administratively suspended by the Bureau of Motor Vehicles rather than the court. And that's typically for accumulation of points or some other deficiency in your driving record. Every time somebody receives a moving violation, they get a point or two or more on their driving record. And if you accumulate 12 points during the course of a year, that will result in a suspension. So there are a variety of ways over and above being convicted of a crime that a person can lose their right to drive a car, their privilege to drive a car.
And it takes so long to get those points off of your license. And if you get another violation, they start all over with the timer. It could take 2 to 3 years to get points to drop off of your license. So it's really important to have an attorney to help you fight for your license and make sure that those points don't accumulate there if you can. I know some attorneys that just specialize in that.
That's right, Erica. And those are situations where it becomes worth it to fight traffic tickets. For a lot of people, they get a speeding ticket. It's going to result in a couple of points and it's going to cost them a few $100s. And in those situations, is it worth it to fight the ticket in court? Maybe, maybe not. Certainly to keep those points off your license, and which the points are often tied to increases in insurance rates, it may be cost effective to fight that ticket. But when you start to get into the 12-point range, when you're in the really +6 range, now every point counts, because as you said, Erica, fighting those tickets and keeping yourself away from a 12-point suspension becomes critically important.
Well, I'm glad that you're bringing this up. So let's review, what are driving privileges?
Driving privileges are the result of an application to the court listing specific reasons and needs to travel while you're under a suspended license. Driving privileges and an application for driving privileges is not guaranteed. They really depend on the appropriate application, content of that application, and the background characteristics of the person asking for the privileges. A court can issue privileges for a variety of reasons. The statute says that they can be issued for occupational, educational, medical purposes, taking a commercial or a regular driver's license examination, attending court-ordered treatment. And then there's a catch-all phrase that allows the court to issue any privileges that it deems appropriate. So for single parents to be able to go get food for their children and take their children to their extracurricular and school activities. So privileges are a limited reason to drive for very specific purposes and allow a person to participate in modern society, which almost requires a vehicle, without having to incur the costs of constant Ubers or cabs or mooching off of friends.
I'm just wondering though, because we've mentioned so many different reasons that your license could be suspended. Can you tell me, is there a reason that maybe you wouldn't get these driving privileges?
Yeah, there are a lot of reasons, Erica. We struggle with convincing the court that people who specifically travel around the area for work should be trusted with limited driving privileges. So, let's say you're some sort of contractor and you're driving from house to house to house every day. You don't have a primary place of business. You're not going home to work and back home again, but rather you're driving around the region on all these house calls or calling on businesses and things of that nature. The court is very, very suspicious of people asking for those kinds of privileges. As we get into the, any other reason the court deems appropriate, there can be some real fights to demonstrate to the court that those privileges are truly necessary. Privileges, limited driving privileges, are available under most circumstances, under most convictions. But a CDL holder, a commercial driver's license holder, can't get privileges to operate their commercial vehicle, even under limited driving privileges. They can keep their license active, they can renew their license, but they can't actually drive the commercial vehicle. And the actual driving privilege paper really becomes the equivalent of their driver's license, of anybody's driver's license. And the terms in that, that paper have to be strictly followed, or they can have those privileges taken away. Those limited privileges taken away can result in new charges, more suspension time. And of course, there are a variety of convictions that you can't get any limited privileges on at all. So, for one, there was a rash this summer of people driving ATVs recklessly through Columbus, Ohio. I think it was starting to kind of become a national trend. And a lot of those people got charged with fleeing a police officer. And that's a license suspension that allows no privileges. So that's a 3-year hard suspension, no driving for 3 full years.
Wow. I mean, that sounds incredibly rough. There are good reasons for certain people not to drive, that's for sure. But it's definitely worthwhile getting an attorney if you feel like the situation didn't warrant you losing your license. And we talk about that happening all the time. So thank you so much for keeping us up to date on that.
My pleasure, Erica. You are welcome. And thank you for joining me on this journey, Erica. It's been over a year and over 50 episodes covering topics from false allegations of sexual assault to driving privileges and sealing criminal records. We've talked about some of the biggest moments in civil rights history, from the rise of the Black Lives Matter movement to the Capitol riots. It's been an amazing run, and I want to thank you so much for coming on this journey with me.
You are welcome. It has been my pleasure, and I have learned a lot. It's always very educational talking to you. And I know personally, I am going to be more careful about allowing people to track me on my certain websites and apps. And I'm not going to send my DNA into genealogy sites. And I'm going to stay out of trouble anyway, but there's a lot of great information that you've given just the common citizen that isn't necessarily a criminal, but could be in the wrong place in the wrong time.
Well,
So
Erica,
thank you.
I always say, Erica, nobody expects to be charged with a crime, but anybody can be at any time. So it could happen to you. And if it does, call me. Well, we're not to that part yet. Everybody out there, thank you so much for listening to today's show and listening in the past. To become informed about the hottest topics in the criminal injustice system, police and government accountability, driving privileges, and everything you need to know about your constitutional and civil rights, check out the law office of brianjones.com. Find us on Facebook, facebook.com/Central Ohio Criminal Defense, or on TikTok, Instagram, and Twitter at TLOBJ. We'll be back next week with a sui generis perspective on the next big thing in civil rights and criminal injustice system news, as well as an update on the current COVID-19 pandemic effects on the criminal courts and the rights of Ohioans across the state. Erica, my grandfather always told me don't do anything I wouldn't do. And to that, to my friends, especially you, Erica, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.